dismissed. But despite because Mr. Rao is so magnanimous that he said, I will consider. So we will, better you go. Representation only yesterday, Mr. Given.
Because the order was made widely public, in fact, I went yesterday.
Which order public? Rejecting your non-local.
My lords have decided. Yes, that order is made public.
No.
It's on the web portal.
No. Which order, Mister?
Your lordship's order. My lords, your lordship's order.
No, so that doesn't depend on this thing. It's still the law that you are indolent. Whatever it is, Mister. Shall we dismiss the petition, or you want a direction to consider?
Direction to consider in today's second list, because today is the last day, Millets.
No, this way we cannot set the clock back, Mister. What can be done?
Next list.
31st of next round of counseling.
Next round of counseling.
Yes.
Because I approached, Millets. In fact, I was supposed to make a submission.
Mr. 31st of August, you have submitted a representation. Please understand. This we cannot force them to set the clock back. Like when that's all time bomb. You knew when your colleagues, like your students, like you, came to the court and were prosecuting. What were you doing? Tell us. No explanation, obviously. Then it was widely made known. Then you widely rushed to this.
I have too many. Only on the point of my bona fides.
At this point of time, nothing. No, this is the best thing.
No, next round, Millets.
In this writ petition, in this writ certified copy today. Today. We don't want to give you relief, Mr. Because we told you.
After the order was...
No, it's very easy for me. We are making a departure from the view taken in Karnataka High Court. I am making a departure because of your submission. Otherwise, if you ask us to decide, we will dismiss the petition saying that 30 days after you have filed, delay disentitles a person under Article 226, and delay of every day in such academic matters counts. Therefore, dismissed. It can't be like that order is so everybody will now keep on rushing, saying that I am a local candidate.
Yes, sir.
Mr. Rao will not entertain such a claim. This, with consent of the parties, the matter is heard finally in this writ petition, the petitioner inter alia seeks a direction to petitioner to treat him as local candidate. Paragraph. Admittedly, the petitioner was declared as a non-local candidate on 2/8/2023. The petitioner thereafter submitted a representation to the university for the first time on 31/8/2023 and has filed this petition today, that is on 1/9/2023. There is no explanation no explanation has been furnished for inaction on the part of the petitioner for a period from 2/8/2023 till 31/8/2023. Full stop. Paragraph. The second round of counseling is already over. Full stop. Paragraph. In view of Mr. Rao, delete on Mr. Learned Counsel for the petitioner as well as Mr. Rao jointly submit that the second round of counseling is over today at 1 p.m. Full stop. 1 p.m. The matter is being called at 1:40 p.m. Full stop. Therefore, Learned Counsel for the petitioner submits that the university be directed to consider the claim of the petitioner as a local candidate in the next round of counseling. Mr. Rao, Learned Standing Counsel for University fairly submits that the claim of the petitioner shall be considered as local candidate in the next round of counseling. Paragraph. In view of aforesaid submission and in the facts of the case, petition is disposed of in the direction that in case that the claim of the petitioner for being treated as local candidate shall be examined by the university in the next, in the next round of counseling, which may be held for admission to MBBS stroke BDS course, it is made clear that this court has not expressed any opinion on merits of the claim of the petitioner. Accordingly, petition is disposed of, certified copy today.
Deeply overlooked, perhaps.
Yes,
Subject to your lordship, similar. A similar direction may be carried out.
all right, same order,
Yes.
same order.
But representation we take today.
Huh?
Representation is 1-9.
Ah,
Yes, only that.
representation has submitted
Dated
today 1990,
1990.
same order, madam. Disposed of, certified copy today.
Public.
Ah.
Yes.
Yes.
This petition lawsuit, the petition after the B category lawsuit,
Huh?
the management quota, C category is not made up.
Management is very generous. Which page?
He has not included the hard copy.
No.
Hard copy is only considered representation.
Ah, consider. Which we order we have passed, Mr. Rao, if you can
Yes,
tell. Huh?
It says, my lord, 62.
60.
In this matter, lawsuit.
Disposed of, certified copy today.
Representation?
Representation lawsuit, yesterday lawsuit, I filed the application lawsuit,
31.
page number 50 lawsuit, page number 50.
Yesterday.
Page number 50 lawsuit.
They have not, it has not even reached university, right? Mr. Rao is not aware.
Online lawsuit.
19.
Yesterday,
Yesterday, 31st of August 23, disposed of. Ah.
disposition charge, time frame lawsuit. CC today lawsuit.
Goes without saying, we are sitting overtime and doing this. What do you think? Delivering you copy on Tuesday? Not Tuesday. We will do it today. Certified
category
copy
matter.
today. Yes,
B category, my lord, under management quota, your lordship.
management put, Mr. Rao,
Because, my lord, because of he has not. My lord, I
Which
filed the
page?
order copy also, your lordship, my lord.
Which
Number
page?
20. Page number 20 is the same order, my lord.
22.
Similar order, my lord.
Huh?
But that is different, my lord.
Different.
But he had a
Different.
The order is which?
But next, this, earlier case, my lord.
Earlier case. Huh? That page, which page, which? 62, same order in item number 4 also disposed of. No, everything you write, no opinion on merits, right? Yes.
Right.
Yes, fresh petition.
Against the local category, claiming under local category, your lordship, as with item 1 and 2 say.
So, what, how many lunch? More? No, 5 we have heard, no? 3 more. You are the counsel in all the remaining matters?
No, only
Only
one
one.
matter.
What is it?
Yesterday matter, my lord, yesterday's.
He withdrew and filed a fake petition.
Yes, my lord, it's a local candidate of, my lord, the study.
Uttar Pradesh University, Uttar Pradesh State.
Local candidate, he wants now local candidate of
In
state of
Telangana.
Telangana.
This. What do you say, Mr.?
Studied 4 years there, your lordship. She studied 4 years by virtue of her mother's employment, shifted to AP, your lordship. But from born and brought up till 8, she was here only. 9th, 10th and 11th, 12th, she studied.
Shall we say that Tehsildar will conduct an inquiry and all that order? Not opinion on merits of the claim, conduct an inquiry, issue 5 days and then decide. Mr. Rao,
As per the presidential order, my lord, he is a non-local candidate.
so you
we
want
cannot-
to,
we
so
cannot
you
go-
seek instructions.
We cannot go beyond the presidential order.
No, so you seek instructions, then we will list it on Monday.
Yes, sir.
Heard on the question of admission, Mr. Rao, learned standing counsel for R2 accepts notice and prays for short adjournment to enable him to seek instructions. List on 5th of September 23. Because now it can be only third round.
Yes.
So second is already over. Yes. Yes, Mr. Kaushik.
Lordships,
What is it?
in fact, your lordships, previously when the
Huh?
matters were taken up,
Huh?
I've sought for a specific interim.
100%. This is coming up on 6th September, correct?
Yes, your lordship.
Then list on what the interim order which is the order which is passed.
The interim order, your lordships, I have. sought for-
Counseling is already over, my lord.
Ah,
Counseling is already over.
you have, so 6th of September,
Any early date, your lordship, so that at least
So all other cases are listed for 6 September. Third round of counseling can't be held. And in any case, if you succeed, we will decide what is the relief you are entitled to.
oblige.
Prepare a synopsis like the one NCC candidate argued, right?
I shall, your.
The council, how he formulated submissions and gave case law. That's the way.
Certainly, your lordship.
Don't like I was born in 1974 at a small village in the
Certainly.
state of Andhra Pradesh.
Certainly.
Learned heard on the, no, but this is a fresh matter, right? Learned counsel for the PT. You have appeared, Mr. Learned, you have appeared in other similar matters.
Yes, your lordship.
Huh? Or it's a fresh matter or old petition?
It's a fresh.
One is a fresh matter, and another two, your lordships, have filed IAs.
Right now is 2-4. Don't confuse, Mr. This is 2-4.
3479 is a fresh matter, your lordships.
Learned. What's your name?
Anup Kaushik Karwati.
Learned counsel for the petitioner submits that he has filed a similar writ petition, namely WP number
18047.
18047 bar 2023, which is
6 September.
which is fixed for hearing on 6th of September 2023. Full stop. Learned counsel for the university on instruction submits that the second round of counseling is over and the dates for third round of counseling are yet to be announced in view of aforesaid submission. List for analogous hearing along with other connected matters on 6th of September 23, right? We will hear you on 6th September. And what this item 2, you have got it listed again, right?
I have
Fresh
filed,
IA.
I have filed IAs.
And got
Because
it.
your lordships have,
No.
on the last occasion when I have made a mention, your lordships have instructed that I might as well come with an IA. So I've sought for an expeditious hearing and a stay on the second round of counseling.
Fix a date of hearing, it is already fixed, like date of hearing. Heard on IA number 5 of 2023. After hearing learned counsel for the parties and taking into account the fact that the second round of counseling is already over and similar writ petitions are already fixed for hearing on 6/9/2023, IA 5 of 23 is allowed. Let this petition be listed for we don't say hearing, it will listed on 6/9/23 along with WP number along with other connected petitions, right?
Both the matters.
Both the matters, same order.
Oblige.
So, Mr. Start preparing that synopsis, list
Certainly.
of dates and your submissions and separate compilation of case law. On that compilation, if you are relying on a Supreme Court judgment, it should be indexed which paragraph number. If you are relying on para 423, write that also. That
Please.
helps the court, right?
Oblige.
Yeah.
Number 95. Move it.
Same. It is not. No. This is a letter. See, last time there was one time to file objections. Yes, Mr. Not saying anything. Yes, you should. You want to file objections?
Objection.
You appear for whom? Learned counsel for defendant number 29 and 30. Again, and 39.
What are the LRs? Dependent number 39.
And LRs of, and learned counsel for LRs of defendant number 39. Pray for and are granted 6 weeks further time to enable them to file objections to the report dated 6/3/2023 submitted by the receiver cum commissioner. I have filed wakalat also. The learned counsel, beginning you write, undertake to file wakalat within a week. Thereupon office to print their names as counsels, and then they pray for.
My lord, be permitted to make mention. My LR petition was allowed on 19/12/2020. But so far, they haven't complied by bringing me on record in LRs. Application number 1 of 2022. This was
Who will comply?
just
Who has to comply?
registry, my lord.
Ah.
Orders have been passed.
All right, registry shall carry out the amendment in the cost title in the light of order dated
19/12/2022.
19/12/2022. In the first you write this amendment, then undertake to file wakalat, and then this order. Yes. Office to. Yes.
May it please your lordship. I beg to represent Ms. Sanita.
Yes. Yes, Mr.
Sachana.
You have to file. You have to file an application seeking substitution of LRs of disease. This point number 1. Condonation of delay. We had granted you time, you didn't do it. It was also, have you filed?
Before your lordships are pleased to peruse the.
No. Ask him whether he has filed 4/8/23.
May I have your lordship's leave to make a submission?
Yes, of course. By all means.
The respondent died in 2015 below.
Huh?
The respondent died in 2015. Why I speak? According to the memo served on us,
23.
according to, may I proceed with the submission below? According to the memo served on us, they executed a will in 2014, registered will,
It's already stated.
bequeathing the property in favor of 3 people, A scheduled to 1, B scheduled to 2 and 3.
But he's not making a decision. Tell him.
Sir, On 4/8/2023, there was an order directing you to submit a application for substitution of legal representative for deceased respondent number 1, along with necessary applications, along with condonation. Have you filed it?
I beg your lordship's indulgence to permit me to submit one thing below. Under this will, the beneficiary also executed a will and she died before she is brought on record as legal representative.
Sir, already this court has granted stay on 23/3/2023. Are you aware of that?
Yes, my lord, that is stated by the earlier arrest by Chief Justice and the present landed judge. I am aware of it.
Yes, thereafter a comprehensive report has to be filed for enabling you to pass for this court to pass final orders. Meanwhile, if you want to substitute the respondent, you have to file an application to that extent.
So to move to
He doesn't want. You don't want to file.
the Hadil I am facing below the
What's the problem?
Hadil I am facing below the before the property vested in the beneficiary. The beneficiary died and executed in it.
Not understanding what he is appearing person.
May I request you to please appear in person before this court to make your submissions.
Appear in person, he is asking. Appear in person in the court. Appear in the person in the court, he is asking. Yes, your lordship, your lordship give some time, so you can appear in the court.
Maxim, don't you explain? You appeared on the last date of hearing. You are not explaining to arguing counsel what we have about the order which we have passed and what he is required to do. If he doesn't want to make an application, we will proceed. If he wants to make an application, then he should pay for time. He is doing neither. What should we do? Tell us. You understand, right? You appeared before the court on the last date of hearing. We granted you time. If you don't want to file an application for substitution, fine. We have said that we pass orders. You are neither paying for time, nor you are saying that we will not make an application for substitution. What should we do?
Millard, may I submit, Millard, in this matter? Millard, in this matter, there are two will deed. Before the respondent is brought in the record, Millard, he has died. So, Millard, the will is in the question now, Millard. So, if you want to submit for that reason, Millard.
Madam, if you are questioning the will, this is not the forum.
Millard will appear in person, Millard, will explain before your lordship. Your lordship may grant some time.
What's his name?
KB Satyanarayana is appearing.
Learned counsel appears through video conferencing and prays for adjournment to enable him to address this court in person. List after 1 week.
Oblige. Not one week, Millard, 2 weeks. He'll be out of station.
2 weeks. 2 weeks. 3 weeks. Why 2 weeks?
Oblige.
3 weeks.
I am deeply beholden. I am deeply beholden to your lordship.
Lord, the stay granted by Supreme Court, my lord, second order passed by my lord. The stay by Supreme Court, my lords, matters are pending before Supreme Court.
Which petition?
Last time it's.
So against the order dated 4/5/23, you had filed SLP.
Yes, my lord, spent.
Huh?
Yes, my lord. Next date is 18 September, it's coming up.
SLP
SLP 1232023, but last time passed. 123202023.
23.
Yes, my lords.
Yes. 4/8 we have granted time. Hey, madam, where is the order sheet? Not here. Yes. 4/8. That is only for the limited period. So what happened on 18/8?
It's adjourned to 18/9, my lords, 18 September.
Again, yes, it is the list after disposal of SLP. Learned counsel for the petitioners once again submits that the proceeding in SLP SLP number 12320/23 is fixed for hearing on 18/9/2023 before Honorable Supreme Court. Paragraph in view of aforesaid submission. Hearing of this petition is deferred. Signed I. However, counsel for the parties are granted the liberty to produce the order passed, which may be passed by Honorable the Supreme Court in the aforesaid SLP.
Actually, there is a respondent represented, but the lordship said petition but respondent represented. They moved the Supreme Court, they obtained that order.
You are appearing.
I am appearing with petitioner, he is appearing for the respondent.
He gives an impression as if he is appearing for petitioner.
No, my lord.
You didn't say-
challenge the order of the.
He tell us-
He challenged the order. He challenged the order of this court, my lord.
But you didn't say that I am appearing for respondent. We got the impression that you are for the petitioner, respondent, madam. Learned counsel for respondent subjects. Yes.
Obliged.
I am appealing for the respondents, my lord. I request your lordship to grant 3 more weeks for filing counter affidavit. my lord. Item
And
number
for the
98, my
petitioner's
lord.
lord. Time may
Requesting
be
3
granted.
more weeks, my lord.
Mr. Santosh
Yes,
Kumar.
ma'am.
S. Santosh Kumar, learned government leader, once again prays for adjournment to enable him to file counter list after, he is permitted to do so list after 6 weeks.
This matter, I am appearing for the petition below. I am repeating Muhammad Adnan below. I may be permitted to withdraw the petition to avail the alternative remedies below.
Learned counsel for the petitioner seeks leave of this court, to withdraw the writ petition with the liberty to pursue the remedy which may be available to him in law with regard to his grievance. In view of aforesaid submission, the petition is dismissed as withdrawn with liberty as aforesaid.
I am appealing for the respondent 1 to 6 months. I am appealing for the respondent,
Even for respondents, 7 and 8 months.
requesting 4 weeks time for filing counter.
Madam.
Matter, my lord.
Madam,
You have filed
same
counter?
word in item number.
Also file counter.
Learned senior counsel, learned Mr. Swan, yes,
Madam, I am appearing for the petitioner,
fine.
but under the guise of this impugned proceedings, they want to in a survey proceeding, they wanted to deliver the possession which is contrary to the law laid down by division bench of this honorable court. And also, when their civil suit is dismissed, and also, when their application for delivery of possession is they have withdrawn before this honorable court. But there is so much of record, which I take your lordship, kindly see page 24, which is the order impugned herein.
What
Kindly
is,
see the represent.
no, Mr. Counsel, government advocate and learned senior counsel for 7 and 8, they are paying for time to file counter. You want, meaning that you want some interim order to be passed, right?
But they are, no, your lordship, they are demolishing the structures which photographs I have.
Kindly see,
You-
they are seeking stay of survey. Actually, survey has been conducted, as I understand, in the month of May itself. The survey proceedings are to be published. If they have objections later for the survey.
Survey
proceedings,
demarcation and delivery of possession, they are saying.
my lordship may kindly see that survey has already been conducted. Now the survey proceedings are being published by the government, as I understand.
When it has.
I think it's in the month of July, it has been concluded, madam.
I need to get instructions, my lord.
Your lordship, kindly see
The
page.
petitioner challenging the proceedings dated 24. There is petitioner challenging the proceedings dated 24/5/2023 minutes. Now,
1 minute, Mr. We will hear you, don't worry. But let us understand what is it. You are referring to documents without telling us what is the interim relief you are seeking. So we are trying to understand from respondents, what do you want? Then you will read 478 and 440. Yes.
in this case, petitioners declaring, challenging the action of
No,
the
no,
respondent.
the senior counsel is survey demarcation delivery of possession of survey number 57. Have you filed
Lordship,
counter?
will file counter, madam.
No, but what happens to survey when it has been done?
Your lordship may kindly say, as I understand, the survey notice which was issued in May 23, Thereafter, in July 23, the survey has been conducted and the government, the concerned officials are in the process of issuing the survey proceedings. It is only thereafter everything will happen. If there are any objections, as I understand, well, not in fact, originally after issuance of notice, as I understand, certain parties had submitted their objections, which were already dealt with by the concerned government officials. Thereafter, survey was conducted. The survey findings are awaited from the government. So let the government appraise the suburb.
Council, this, in fact, this is a part of CS7, right?
Yes.
Okay, if that is the
Yes,
case,
sir.
that is the case, and you, the receiver has already filed a report. Please obtain a copy of this, and if you are objecting, file your objections. After accepting the report, we will hear this writ petition.
Milord, so far as Milord, this is concerned, report has nothing to do with, because Milord, in fact, the receivers themselves have filed a counter opposing Milord delivery of position, saying that we have not signed this, the
Sir,
plan
please
that is-
understand, this report was filed of late. It's a new report. Are you aware of that?
But that new report, Milord, they are denying everybody's right. But that is a different
Then file your objections to that. It is nothing but parallel proceedings. It amounts to parallel proceedings. You
No, no, no,
don't want to file objections to that. This writ petition can be heard. Tell me.
No, my small submission, Milord, for this case is, Milord, it is the unofficial respondent, official respondent are trying to, you Lakshmi kindly see page 437, they are under the guise of survey, they are interfering with my possession and they are trying to demolish the structures. I filed, Milord, the bulldozers as late as 18th August 2020.
When the final decree proceedings have not been passed till date.
It is passed, Milord.
Where?
There is a
You better appear in physical mode and argue. We are unable to accept your submissions.
That's correct.
Need to file counter matters anyway.
It has to application to the MO and no other can enter. The division bench confirmed that, confirming the circular.
No,
I may-
Brother,
Four
you
documents
said that you appear in person,
consideration
right?
of the guise of survey, but they can't start to deliver the possession of the property. Milord, kindly see
Yes,
that,
survey
this division bench of this honorable court at page 364, Milord, page 364.
52 schedule A next to preliminary decree 4750. Everybody is taking.
This is a petition, Milord, where learned single judge of this honorable court, Milord, disposed of the writ petition, saying that the prayer is also extracted for a delivery of position, and since there is already earlier direction, no further direction can be granted. But division bench of this honorable court noted the prayer and said, in fact, this writ petition should have been dismissed on that ground. A delivery of possession cannot be. It is a matter pertaining to the civil courts, where they have to go to civil court. But they have sought for delivery of possession before the Tahsildar. That you Lordship would find in the impugned order at page 25, Milord. They sought for delivery of possession from the surveyor, which they failed before this honorable court. They filed an application for delivery. Receiver objected to, saying that the plan appended is bogus. Then they withdrew the application which they filed before this honorable court in CS 7. They withdrew it, and then they goes to the survey people. They readily entertain. Collector entertains it.
That appear in person.
But this honorable court said it is only the Mandal surveyor who is the primary authority, before whom only an application for survey can be made and entertained. Here, collector writes straight away to RDD. which is found fault, my lord, by this honorable court, a division bench of the learned single judge, referring to all circulars. But that judgment, my lord, you lordship would find, my lord, at page 399, my lord, a relevant portion, where entertaining of applications straight away by the higher ups, contrary to the circulars, is found fault. Even in there also, my lord, RDD who entertained the application.
What is simple survey of
And the first division bench, my lord, at page 368, my lord, relevant portion.
election the grant. Yes, to
Application
find the
division bench of this honorable courts, my lord, held that it is the realm of civil court.
Lordship may kindly permit us to file counter. Lordship, in fact, in this case,
No,
government
no,
had filed.
Mr.
And
This
then
is the
with regard to
technical,
jurisdiction
Mr.
of
Counsel,
RDD in
Arre, Mr.
entertaining survey
Counsel for
directly,
petitioner,
which is
can you-
filed by a learned single judge, which was approved, my lord. Learned single judge order is at page, relevant portions are at page 392, my lord.
the moment will.
Hello, counsel. There is a technical issue. We are not able to hear your submissions. Please appear before this court in person and make your submissions. We'll take up next week.
On account of technical issues, comma, this court is unable to hear the submissions made by learned counsel for the petitioner list next week.
Obliged.
That's want to file Miller objections, but the commissioner's report in both the cases, appeal for the petitioners. Not to grant me 2 weeks for filing objections, Miller.
Last time we had granted,
That's I could not make it.
learned counsel for the petitioner praise warrant is granted. The applicants praise warrant is granted 6 weeks further time to enable him to file objections to the report submitted by receiver cum commissioner.
Obliged.
Same. 6 weeks. 103. 103 to 105 also same. Call madam, 103. Hundred two same order, madam, 6 weeks time. And what happens to 103? 103, 6 weeks time. 6 weeks too. Same order, madam. 104. No representation, let objections, if any, to the commissioner's report be filed within 6 weeks. 105. Call, you have to. No representation, let objection, if any, to the commissioner's report within 6 weeks. 106.
Miller, in this matter, Miller, I'm appearing in this matter, Miller. Miller, I want 6 weeks time, Miller. I'm
Same
questioning
order.
also.
Praise for adjournment.
Bless.
Praise warrant is granted 6 weeks time to enable her to produce the succession certificate list after 6 weeks.
May I request a lot, kindly grant me 2 weeks time to file objections to the report.
4 weeks.
4 weeks.
Praise warrant is granted 4 weeks time. Learned counsel for the applicants petitioners. Praise warrant is granted 4 weeks time to enable him to file objections to the commissioner's report.
All right. Yes.
In this case also, respondent has to file objections to the report submitted by the commissioner minutes. Time for the appellant.
Learned counsel for respondent praise warrant is granted 6 weeks time to enable him to file objections to the report submitted by the commissioner. Yes.
The petitioner wants to file successor in 4 weeks time.
What wants to file?
Successful certificate.
Learned counsel for the petitioner, praise fund is granted 4 weeks time to enable him to produce the succession certificate. 110. Yes, Mr.
Doctor, grant me 2 weeks, my lords, for complying of his objections. I applied for certified copies, my lord, for furnishing the amended copy of the cost title. That I'm awaiting that. I filed a memo to that effect.
4 weeks time to file amended cost title. Learned counsel for the petitioner, praise foreign is applicant, whatever. Praise foreign is granted 4 weeks time to enable him to file amended cost title.
Both cases. Next item.
111 also.
Yes.
111 also. Same order. Yes.
May I please your lordship, I'm appearing for respondent number 8, my lordship.
Yes.
And your lordship, I have
Somebody, you are not visible, Mr. Counsel.
your lordship, there is some technical issue. Your lordship.
All right. So what, you want time, right?
Yes, my lordship, like I have been roped in this writ petition, my lordship, as if I have filed.
No, Mr. You should be visible to us, right? Why don't you appear in person?
Much obliged, lordship. Kindly grant us some time, my lordship, next week.
Learned counsel for the petitioner, respondent.
Respondent number 8, my lordship.
Learned counsel for respondent is for adjournment. List in the next week.
Much obliged.
Learned counsel for the petitioner prays for adjournment on the ground that the matter is to be argued by senior counsel. List after 4 weeks. What is applications? None for the applicant. None for the applicant. In this application, the prayer has been sought for. No, none for the applicant. We have perused the record in this application, the petitioner has has prayed for passing of final decree in favor of the petitioner in respect of the land measuring 10.12 guntas in survey number 1/1 of Hashmatpet village, which is part of item number 2 of schedule Roman 4A of preliminary decree dated 8/6/1963, passed in CS number 14 of 1950, paragraph 58, sorry, 58. A new receiver has been appointed by this court who has submitted who is yet to submit a report. Therefore, at this stage, in the absence of report submitted by the commissioner, prayer for passing a final decree cannot be entertained. Line below the application, it is disposed of with the liberty to the applicant's petitioners to approach this court at an appropriate time. After the after submission, not appropriate time, delete. After submission of the report of the commissioner, accordingly, application with the aforesaid liberty, application is disposed of. Now we have said none present. None you have said.
Lord, this application, Lord,
150.
under Order 21 Rule 97, Lord, objections were raised by the Lord office. Lord, I will complain, Lord, 4 weeks time may be granted, Lord.
Mark is present.
I will
Learned
permitted
counsel
to
for petitioner prays for it and is granted 4 weeks time to enable him to comply with office objections.
Lord, I am permitted to go through the Lord objections raised by this.
Of course. Yes,
Next one also similar, Lord, 116 also.
116 same matter. Yes. 117.
117 to 125 also there are certain objections, I suppose.
117 to 125.
117 to 125.
That's what we are seeing.
But there are certain objections. Your Lordship may grant me some time and complain.
4 weeks. Learned counsel, Mark is present, learned counsel 170 to 125. Learned counsel for the petitioner prays for and is granted 4 weeks time to enable him to comply with office objections. Yes.
Next. With the.
Letters. Then we have to open. Because we were the wanted in, became reporting 7. So we continued in 15. And then thereafter we saw these. Only 8 years later. In his place, we have to procedure. In fact, I requested the next step. He says we continue in the 7 second. We don't have to be in right. List next week.
CS 14 minutes were pleased to appoint Mohammad Nizamuddin as a receiver and commissioner minutes. Report is awaited minutes. Minutes may kindly take up this matter after submission of report minutes.
Report. Report.
Yes.
There are already reports.
Await the report of the commissioner. Let the matter be listed after the report submitted by the report is submitted by the commissioner stroke receiver. Interim order shall continue.
It is for the receiver to submit report minutes.
Receivers, they are not coming. Receivers, they are not coming to the tenders.
We'll take it up next week. Delete. Delete. No, Mister, for some reason we are saying that we will list it next week. Next week, you are protected by an interim order. It will continue for 6 days or more days. We will take up. Later on when you, why do? Later on you file when it is to be taken. Or you file in the office if you want to. Why to give it here? Yes.
This matter also minutes. This matter also minutes. Identical to item 127 minutes. This matter also minutes. Report of the commissioner is awaited minutes.
Mister. Report is awaited 128.
He is not representing in 128 minutes.
Not appearing, then why are you standing there? None for the petitioner.
127 it is
None for the petitioner. let the report be submitted by the commissioner. List after 4 weeks. 129.
Because in this item 129 and 130 also, there is a direction for awaiting the report of the advocate commissioner.
Let the awaiting, no, delete awaiting submission of report by the commissioner. Hearing is deferred. List after 4 weeks. 129, 130. Let's look. Nobody is appearing for it. This.
Lordship, kindly short pause of my side.
Huh?
Advocate General is appearing in these matters, my lords. Lordship, I will inform my lords. I'm not aware, my lords.
No, before a special bench, right? Can you?
Yes, my lords,
speak
I'm
up?
aware, my lords. I thought so.
These are first appeals, 4 first appeals arising out of common judgment in respect of 2 suits. It takes a lot of time because there is a voluminous record. The entire previous history is required to be placed before your lordships. That is the problem.
We only can request the young colleague assisting you to prepare a synopsis to cut short the time instead of those. Got it, Mr. What's your name, young man?
I have
What's your
filed.
name? We are asking him something.
Akash Upadhyay.
Mr. Akash Upadhyay, prepare a date-wise what happened when. Prepare and give seat to senior.
I
So that we can cut short the time.
filed already.
We don't have the luxury of hearing it for months together, right?
In fact, I have filed all the details earlier. They are on record. I have filed so many things there.
No, we are also ready to hear, but.
Sorry, Millet. Let's, one
He said
short.
Advocate General, you are not Advocate General.
Millet, I'm attached to the office of advocate.
He said Advocate General will argue. Yes.
Millet, I'll prepare a
This is appeal under 96.
Yes, Millet, one short point that was to be educated on the last occasion, I made a representation of your lordship is the preliminary decree.
Under 96.
May accommodate me by week, Millet. I'll be ready with the chronological dates, Millet, and I'll place it. I will not take more than 5-10 minutes in this case, Millet. My country.
He says that huge. That he said that it will take
Millet,
senior counsel.
Millet, it may be their case, Millet. As for the case of the government is, Millet.
You are the appellant, right?
We are the appellants, Millet.
Two appeals at least we can decide.
Yes, Millet. Yes, Millet. 10 minutes, Millet. My lord's time, 10 minutes, I can satisfy your lordship. This appeal is
Mr. Upadhyay, tell your senior that they are saying that they will conclude in 10 minutes.
10 minutes, yes.
No, they are saying that we will conclude. You are saying days together. It's their appeal, right? What date?
Any date, Millet. Next week or that next week, Millet. I'm ready, Millet. 8th, Millet, any date, Millet. I'm sorry. Other than 8th, Millet, any other date, that's a senior's request. Millet.
What is the voluminous record? It's there. This
15th September. 15th September.
15th September.
15th September.
I have inconvenience up to 20th. In that event, your lordship, we have up to 20th. 22nd, your lordship may have it.
22nd September.
Yes, obliged.
31 to 154. He prays for adjournment to learned whatever. You are
Government leader, Millet.
either attached to
AGO.
Place for adjournment to enable him to prepare a synopsis and produce the same.
Everything is
And
fine.
prepare a synopsis along with written submissions.
Yes, sir.
And to produce the same. List
Thank you.
on 22nd September 23. You also, Mr. Upadhyay, filed written submissions.
I request Lordship to direct the office to verify entire record which is produced by both the parties. We have filed several books here because I don't think.
Then
that
we
they-
don't have any reason to disbelieve that it's not in existence. Supposing you file that that it is missing and all that, how do we know? We don't know what is at this point of time. We don't know against which judgment and degree the appeal has been filed.
After serving them only, I have filed all those records.
No, but can you say that it is missing? It is a case then for an inquiry to be conducted.
I am not saying that. Let them place the entire record so that there is a lot of record is there. All right, let it be there.
Record not there.
I have prepared the compilation.
They will make it available, mister. You please ask the young man to focus on written submissions, which will be prepared under your directions, right? That's a better way. She will take care of the record and produce it.
Submission. Oh, will you permit me to give some books, Lord, on non-legal issues? I'll give the list, Lord, will you permit me? I'll come and give the list. I want to give non-legal books from library.
In this case, whenever it is called 22nd September, you can give the list.
Not for this case. General, I want to give some books.
Library.
General books. I want to give
some library books. You can donate the books. We will tell Registrar General. You give, donate such a beautiful library by the Bar Association has been, but why are you mentioning? You should go talk to President of the Bar Association.
Next time.
Your Lordship, humble
We'll
submission.
take it up today itself.
No,
Today,
my lords. Next week, my lords.
Next
I'm
All right,
taking a
next-
listing of the matter.
all right, next week. No, we thought it's urgent. So next week, right?
Your Lordship, humble submission. Arbitration application 32 of 23, Your Lordship. It's
Huh?
not arbitration application 32 of 23. It's not been listing, Your Lordship, for since last 3 months, Your Lordship. So kindly requesting,
What is the stage?
Your Lordship.
What is the stage of the application?
Stage is to serve the notice to the respondent, Your Lordship. We have
Has been
served.
served
Yes, Your Lordship. We have served and
next week.
With your lordship's kind permission, my lords, requesting listing of 5 connected arbitration applications, my lords, filed under the section 11, my lords. The stage is at, the notices have been served, my lords, on this. Much,
So they will seek time to file counter, right? 4 weeks
my lords, they've not come on record as well.
next week.
Much of that.
May I make mention, my lord, subject to lordship kind permission?
Yes, please.
My lord, arbitration application, my lord, number 229 of 2022.
Ah.
My lord, the other side also appeared, my lord, and they took time, my lord, for filing counter. Since then, my lord, it is not getting listed since April. Lordship may kindly have next week, my lord. Right.
Next week. Next
Obliged.
week.
229 of 22. Obliged.
No, but you should give a memo, right? It's not online doesn't mean that you will not even give a memo for listing. Please give a memo. Ask your colleague or junior, somebody, your friend here to give a memo. We will list it, mister. We will list it, but you give a memo, right?
I'll get it done.
Yes.
Obliged.
Yes.
Were purchased from the builder, my lordship. Invitation clause in 25, my lordship.
Notice. Learned counsel for the petitioner. Learned counsel for the petitioner submits that the agreement for sale dated. Agreement for sale dated. Agreement for sale for semi-finished flat dated
December 2000.
1/12/2010 in respect of flat bearing number S2 in second floor of Ravi Kunj measuring 1741 square feet contains an clause 15 of agreement, right? In the beginning you write clause 15 of agreement for sale of unfinished whatever semi-finished flat contains an arbitration clause in view of aforesaid submission. Notice.
Lordship permitted personal notice, my lord.
This all personal notice and proof of service. That's it.
Next matter regarding the S3, my lordship, in the same.
Madam, same order.
Yeah, regarding the S3, my lordship.
Flat number S3.
S3, my lord.
Madam, flat number S3. Same order. Notice.
Regarding this also personal.
Personal. None for the petitioner hearing is deferred list next week.
Lordship arbitration application filed under section 11, Your Lordship, for appointment of arbitration. Applicant and the respondent entered into a plea agreement on
Which clause?
9.2, Your Lordship, page number 24, Your Lordship.
Learned counsel for the petitioner submits that the film agreement dated 20th February 2022 20th February 2020 submitted that clause 9.2. Clause 9.2 of the film agreement dated 20th February 2020 executed between the parties contains an arbitration clause. aforesaid in view of aforesaid submission, issue notice. Personal notice. Yes.
My lordship, page 26 is the development agreement cum irrevocable GPA entered between the applicant and the respondent, my lords.
Learned counsel for the petitioner.
Page 32, clause 18 is the arbitration clause, my lords.
Learned counsel for the petitioner submits that clause 18 of the development agreement dated 25th October 2018 executed between the parties contains an arbitration clause. In view of
My lords, there is a
notice.
interlocutory application under section 9 also has been filed, my lords.
In view of aforesaid submission, issue notice, personal notice, proof of service. What?
My lords, there is an interlocutory application IA 1 of 2020.
No, you can file it in a arbitration petition or separately.
My lords, actually under section 9, if we file standalone for section 9, it has to be filed in principle.
Standalone means
Only for section 9, we will file it in the principle.
what are the rules? Every High Court has made rules under 11.6. What are the rules for the state of Telangana? Who is this person? Is he your advocate? Standing behind.
Client.
Then ask him to sit down. He has engaged you, right?
Yes, sir.
Then he need not stand. Supposing if you go to a hospital, whether your relatives or this thing stand in the operation theater, no. Doctors take care. So tell him that you are taking care of his case. So what are the rules, Mr. Under 11.6 rules? Telangana High Court must have framed rules or adopted rules. I have come across for the first time that 11 petition section 9 is filed. Address on the question of maintainability. Ready? Not ready. Brought rules? No.
My lords, but the act does not preclude the High Court from granting the relief under the section 9 also.
No. It does not preclude. This all settled, mister. Nobody has argued like this without arguing, bringing books, etc. You are relying upon us, right? We will not do it. Carry out research. When a question was put to learned counsel for the petitioner, right there, about the maintainability of a petition under section 9 of the Act in a proceeding under section 11 within bracket 6 of the Act, learned counsel for the petitioner prays for adjournment to enable him to examine the aforesaid aspect. List. Next week. Then why to issue notice? Then there's no point in wasting.
My lords, because it will further delay the proceedings, or let me withdraw A1 and approach the appropriate civil court, my lords.
Now you have got the answer, right? Just like taking chances, you see whether court grants.
No, my lords, being in
This is what we, Mr. We are keen observer, right? So people here appear through video conferencing. Then all of a sudden, the moment we start asking inconvenient question, the technical problem will arise. So like this only.
No.
So yes, issued that personal notice, etc. Then say learned counsel for the petitioner seeks leave of this court to withdraw IA 1 of 2023 with the liberty to file the same before the competent court. Accordingly, the aforesaid IA is dismissed as withdrawn with liberty as aforesaid. Yes.
May I please?
Which clause?
Clause 10, my lord. Clause 10.
Learned counsel for the petitioner submit that clause 10 of the agreement executed between the parties dated 18/4/2019 contains an arbitration clause. Aforesaid submission, issue notice. In view of aforesaid submission, issue notice, personal notice, proof of service.
Obliged.
My lord, this is the application for appointment of arbitrator. Clause number 13 of the MOU dated 14/6/2006, my lord.
14/6/2003 or 6?
2006, my lord.
You have wrongly written here 2003. Learned counsel for the petitioner submits that clause 13 of MOU dated 14/6/2006 contains an arbitration clause. Aforesaid submission notice.
Obliged.
Yes, madam. I have the respondent.
It's an application under section 11, your lordships. It's invoked under franchisee agreement, your lordships. Clause is under
Which clause, madam? What page?
Yes, your lordships.
I'm for the respondent. I'm opposing the application, my lord.
Why?
The reason is the
Yeah, first.
You are ready, right? You are
Yes.
not seeking adjournment.
No, your lordship.
Fine. Which clause, madam?
Clause 17.1, your lordships,
Page.
at page 34. Governing law and dispute resolution. If I may read your lordship.
Agreement dated.
Agreement dated 11/11/2011.
Yes.
If I may read 17 clause, your lordship.
Ah,
Second point, your lordship, second paragraph. Any dispute, controversy or claim arising out of or relating to this agreement or the breach, termination or invalidity hereof shall be settled by an arbitration in accordance with the Arbitration and Conciliation Act as in form that date before the arbitrators mutually agreed by both franchisor and franchisee and appointed by the franchisor and franchisee mutually. The decision of the arbitrator shall be final and binding on both the parties to the agreement. The arbitration shall be held at Hyderabad in English. Further, if one party to the agreement disagrees on the award passed by the arbitrator, then the party shall file before the court of law within 15 days of such arbitration ruling. That's the arbitration clause, your lordships. I have filed for a claim of rupees 30 lakhs, your lordships. There are 3 disputes raised by the other side in their counter, your
when did the claim, this thing, dispute arose?
dispute arose as per the legal, as per the show cause notice issued on 10th.
And after agreement was executed in 11, then what, how dispute arose? When? Probably that's what he wants to argue.
Yes, your lordship. That's the entire point of argument here. The show cause notice was issued on 10/5/2017.
Ah. The show cause notice means what?
Show cause notice to terminate the agreement.
You are an authority, right?
Yes, your lordship.
Ah, that's why you are issuing show cause notice. Otherwise, we were wondering individual, how can he?
We are a company, your lordship. We run schools and give it for franchisees.
Ah, yes, then.
Yes, your lordship.
Issued a show cause notice to terminate the agreement. Then
Terminate
what
the
happened?
agreement.
Ah.
Then, your lordships, we filed a first arbitration application in the year 2021. That was with arbitration application number 158 of 2021.
This is 11/6, right? When you say arbitration application means 11/6.
Yes, 11/6, your lordship, for appointment of arbitrator. However, we withdrew the said application, your lordships. The order copy is filed at page 49 of the petition. The reason for withdrawing the said application is, your lordships, page 49.
You have to seek review of that order, madam. You can't unconditionally withdraw and then furnish subsequently. That is why this order binds you.
Yes,
If it
this
doesn't
order is
grant,
binding.
1 minute. If it doesn't grant you the liberty to file afresh, then it is gone.
The liberty is given, your lordships, if I may read. First paragraph, third line, your lordships. The Learned Counsel.
Page.
Page 49.
Yes. Yes.
The Learned Counsel, third line, your lordships. The Learned Counsel further submits that statutory notice was not issued to the correct address of the respondent, and the steps are being taken to rectify the said defect. In view of the above, the arbitration application is dismissed and withdrawn. However, if new application is filed, the same shall be decided on its own merits. Now, this is the arbitration application we filed in 2021, your lordships, within 3 years from the date of issue of the show cause notice. Period excluded.
No, when you filed?
In 2021, your lordships. Exact date.
No, this order is dated 29/7/2022, madam.
We filed the application on 1/10/2021. 158 of 2021 application we filed on 1/10/2021.
No, that is correct, madam. This you have withdrawn on 29/7/2022.
Yes, your lordships.
When this petition, when it has been filed?
This petition was filed
subsequent to July, right?
Yes, your lordship, subsequent to July.
You are referring a date in 21, that's what is confusing. 21st October 22. Yes.
So we filed an arbitration this application after issuing of the legal notice again to appointment, that is on 1/8/2022. which is filed here.
What are the grounds on which your prayer is being opposed? Tell us.
Yes, Your Lordships. The first important point is the limitation point. The argument raised here, Your Lordships, is that
Barred by limitation.
is barred by limitation because the show cause notice was issued in 2017. However, from 2017, the contention would stand if we would not have taken any action. We did not sleep over the rights. In fact, there's a case law filed by the Learned Council wherein it says that exclusively prima facie, if it's barred, hopelessly barred by debt, then the limitation would survive. However, in this,
What case law you are relying?
I'm relying on the same case law filed by Sir, in
Very
which
good.
it says if you do not take,
Mission is not like that.
read
Let
it.
her argue, yes. But we are giving her an opportunity, right? Don't leave it to us, madam. Don't leave the research work to the court. It will.
Yes, Your Lordships, I will read out everything issued. Yes,
No,
Your Lordships.
I mean, this case law position, don't think that we will find out the case law in your favor. You are saying that you are relying on the same case law. I will
I
decide.
will enlighten the court, Your Lordships, why I am relying on the same case law filed by Sir. If I may
23
take your
temperature.
Lordship's attention.
23. Yes. So, first is barred by limitation.
First is barred by limitation.
Second-
Second is with regard to the fact that we have not filed the original or the certified copy of the franchisee agreement. If your Lordship's permits, we'll file the same. It is very well in our custody. The reason for not filing the same was because the arbitration clause is clearly visible in this agreement. If your Lordship's permits, we'll file it on the next date of hearing itself.
What third?
Third one is with regard to the disputes of the amounts, royalty amount. However, that can be decided before the arbitrary tribunal.
So what is the limitation?
Now, the limitation aspect, your Lordships, if I may take your Lordship's attention to the counter.
You first must understand what is their objection to limitation.
The objection is because in 2017 we issued them the show cause notice terminating the agreement, and then they say in 2021 we filed the first arbitration application that was also withdrawn, and then we filed this application. So you cannot seek for limitation from 2017 to 2022 on the same notice. That's the major limitation dispute. It is well agreed, your Lordships, that the notice was issued in 2017, post which, due to some technicalities, the suit was withdrawn. And then we filed this arbitration application. Now,
What is the position of law of counting limitation on a previous cause of action?
it is 3 years, your Lordships. From 2017, 3 years, we have to calculate.
Which provision?
Article 137 of the Limitation Act, your Lordships. So, if I may take your Lordships to...
No, correct. So 2017, 10/5/2017, 3 years you had filed. First application you filed when?
In 2021, your Lordships, post-COVID period.
Within three years.
Yes, your Lordships. On 10/5/2020, the limitation ends, but we've taken the time of COVID and then we filed it in 2021. So that is
Date.
Date of the first agreement, your Lordship, first application.
Application.
First
Fine.
application 1/10/2021.
110. First application filed.
1/10/2021.
Which is that Supreme Court judgment which says that COVID period has to be excluded.
I have not filed it here, your Lordships. But since I was explaining with regard to the Article 137.
No, who suffers if it is not like we told you, madam. You are appearing here to assist us. We will say that after COVID period filed, judgment not cited. He is not expected to cite judgment in
Yes,
your
your
favor.
Lordship. That is.
He will say that it is barred by limitation. That's why, madam, before venturing upon argument, half-hearted, don't do like this. It's not good. It gives a bad impression to the court that half-heartedly you are arguing without making any research. I told you in the beginning, whether you have made research, you said I am relying on same case law.
Pardon me, your Lordship, I shall file the same COVID citation at the next hearing itself.
No, because then I will have to search.
No, I shall file it. I shall file it, your Lordships. However, if I may continue.
Direct counsel for the petitioner prays for adjournment to enable her to prepare the case and argue the same list next week. Yes.
Grateful, your Lordships.
Please, Your Lordship, appearing for the applicant, Your Lordship, the counsel for the respondent has just served his counter, Your Lordship. I have just received the counter. Hence, Your Lordship may adjourn the matter by 2 weeks. I'll file my reply, Your Lordship.
Learned counsel for the petitioner president is granted 2 weeks time to enable her to file reply to the counter.
Deeply obliged.
Please, my lords, I'm appearing for the applicant in this matter. Notice has been issued, respondents have been served, and as per my limited knowledge, respondent number 1 has filed the counter, my lords.
So far as R1 is concerned, I filed my counter, but the senior counsel is unveiled, that's the reason I'm requesting time. R1 I have filed counter.
You have filed counter.
I'm for R4, my lord, submission. R4 is governor of Arunachal Pradesh, my lord. Governor cannot be made a party, my lord, as per Article 361. He is provided a complete immunity. The contractor entered under Article 299.
Mister, what is
State of Arunachal shall be made instead of governor of Arunachal Pradesh.
My lords, I have no objection. Respondent number 4 may be represented through the chief secretary. With permission, I'll seek leave to file amending memo of parties, my lords, if it is the hurdle before my lords.
In view of objection raised by learned counsel for the petitioner, learned counsel for respondent number 4, learned counsel for the petitioner undertakes to amend the cost title by correctly describing the respondent by deleting the name of the governor of the state of Arunachal Pradesh and instead to implead state of Arunachal Pradesh through chief secretary. Let this be today. You will do. Let this be done during the course of the day. Just now. Let this be done during the course of the day.
The notices issued out of no.
You are appearing, right? Government not appearing.
I'm for governor of.
You don't appear for the state.
At this
Then
point,
we have to issue notice.
Please, my lords.
You do it just now, so that
We'll do it.
And the notices issued to governor of no sequence, no consequence.
Obviously, when the name itself is deleted, nothing. Right?
My lords, let notice be issued, we'll take out the notice.
So notice to respond number 4 and personal notice, whatever proof of service. You just do it, Mr. Just
Please,
now, correct.
Please, my lords. My lords, may I request to have it on 29th of September? It's a humble request, my lords. It's the next date of hearing. If I may request to have it on 29th of September, my lords, because I'm an outstation counsel. That is why I'm requesting.
Hey, you first correct it, Mr. What outstation counsel? You don't know. You lead the governor of this thing into a litigation. What is this?
My apologies for that. Please.
You better focus on legal aspect rather than in station outstation.
I missed it personally. That is my
list on 29th September. You just now correct it, Mr. Before leaving. Don't say that outstation, therefore I am leaving.
Please, my lords. No, I'm doing it.
No, do it just now.
Yes, my lords. Yes,
Give the file.
Please, my lord. This petition is filed seeking appointment of an arbitrator, my lord.
But the respondent number.
But agreement of sale.
Before
Yes.
my friend starts, my lord, one sir.
Yes.
I am for the respondent number 1. Now, application is filed seeking the appointment of the arbitrator. In fact, my lord.
You want to file?
Filed by counter.
Counter is filed. Counter is filed on.
A dispute between the landlord and the developer is my lord referred to an arbitrator, and the adjudication stage is over. Now today award is to be passed. Once that award is passed, my lord, I will be settling this claim of the present petitioner. So your lordship may just adjourn it by 1 week.
That has no bearing on my
All right, so you can still argue, right? Next week he said, next week we will hear you. Not
Only
doing
it is
anything.
award is to be passed.
Learned counsel for respondent, senior counsel for respondent, raised for short accommodation. List next Friday.
Yes.
What is the date?
Friday week.
8th September.
Obliged. I may not be there, man. Lordship may kindly accommodate me.
Then what date?
Friday week, man.
15th September. Next Friday is 15 September.
15 September.
15 September 23.
Obliged.
Yes.
My lords, this is a section 11 application filed
Ah.
for, my lords. My learned,
Yes, you had proposed the name.
Justice Venkateshwar Reddy, my lords,
Ah.
Justice Santosh Reddy, I'm agreeable with the.
All right, fine. This petition under section 11 within bracket 6 of the Arbitration and Conciliation Act 1996 has been filed to seek an appointment of an arbitrator to adjudicate the claims and dispute between the parties. We have passed similar orders on the last date, no? You know, parties have agreed. This thing, when the matter is called today, learned council of parties jointly submit that Mr. Justice A. Venkateshwar Reddy, former judge of this court, be appointed as an arbitrator to adjudicate the dispute between the parties. Full stop. In view of aforesaid submission, Mr. Justice so and so is appointed as an arbitrator to adjudicate the dispute between the parties. The parties undertake to appear before the arbitrator on which date? Which date you tell us? 9 September.
9 September.
9 September 23 at 11 a.m. The arbitrator thereupon shall enter the reference and shall proceed. Accordingly, petition is allowed. Yes.
My lords, I am for the applicant for seeking time after 2 weeks. My lords, we have received a memo seeking time for 2 weeks. My lords, senior.
Same thing, respondent, you sought adjournment, right?
My lords, I saw time before.
Now Article 14, he also must get an adjournment. Otherwise, Article 14 will be violated, no? No, this is all, Mr. Please appreciate, this all is a summary proceeding, right? You keep it pending like a civil suit, want it to be decided after 25 years.
My lords, my senior was there here till afternoon. My lords, due to some medical emergency, he has to leave immediately after lunch.
Next week? Next week?
Let's take it up on the 15th. My lords,
Place for adjournment on the ground that the arguing counsel is not available on account of personal difficulty. List on 15 September 23.
My lords, 148 and 149 are also the same matters connected.
Yes, but 147 to 149 are the
Same. One 47 to 140.
May I please? You know, the application is filed for appointing the sole arbitrator. To invoke the-
Notice has not been issued.
I have filed my personal notice, sir. But the proof, sir.
Respondent is served, madam.
Service is not ready, sir.
Proof of service not filed.
It's filed, Your Honor.
When? Show him the endorsement.
That's the card.
When did you file?
On the last occasion. That's the acknowledged card.
Acknowledgement is there, no madam. Then why are you saying?
Even in the list, it's mentioned as the.
Fine. Acha, nobody appears. Yes, mister. Come here. These people stand, you are not visible. Yes. So, which is the arbitration clause, Mr. Simple, right?
Yes, sir.
Nobody is appearing to oppose.
Yes, my lord. To invoke the clause 21F as per page 24 of the material papers.
Sole arbitrator.
May I please? Any dispute arising out of this agreement or
what
in
is-
this manner touching upon it, the same shall be settled up through arbitration.
What, like former judge of this court?
Pardon me, lord.
What is the quantum of the claim?
Amount is 63 lakhs 50,000.
we can appoint a former district judge of,
Yes, my lord. In fact,
of the list approved. Madam, list of arbitrators, mark the presence, none has appeared despite service of notice. This petition under section 11 within bracket 6 of the Arbitration Conciliation Act has been filed seeking appointment of an arbitrator. Paragraph. Facts giving rise to filing of this petition briefly stated are that the parties had entered into an agreement, namely School Academic Solution Partnership Agreement parties had entered into an agreement on 26/12/2018. Huh? Yes, madam, 26/12/2018. Into an agreement, namely so and so, on so and so, namely so and so agreement. Full stop. Clause 21 within bracket F of the aforesaid agreement is reproduced below for the facility of reference. Paragraph. The dispute between the parties have arisen and therefore despite service of notice, the respondent has so company and school have to appoint. You are not company and
for the
school.
company.
Then you have to appoint.
We have sent the invocation notice, Your Honor.
Line
appoint,
below. Despite notice being sent on
1/6/2023.
1/6/2023, the
sorry,
respondent
sorry,
has
sorry,
not agreed.
Sorry, my lord. It's 6th Jan, 6/1/2020.
6/1/2023, the respondent has not agreed for appointment of an arbitrator. Thereupon, the petitioner has filed this petition. Paragraph. The agreement executed between the parties contains an arbitration clause. The respondent, despite being put to notice, have not taken any action to appoint an arbitrator. Therefore, PDJ. There's no list of PDJ. PDJ matter you are given. It's